Good morning, everyone. Welcome to the virtual roundtables on Asian law organized by the Center for Asian Legal Studies. My name is Jaclyn, and I'm the director of the center. Today, I'm very pleased that we have been able to partner with the City University Center for Chinese and Comparative Law to organize today's roundtable. I want to especially thank my former colleague and now professor and director of the center, Jiangyu, for collaborating with us on this particular roundtable. Now, the virtual roundtable series was launched by the Center for Asian Legal Studies to specifically put Asia at the forefront of intellectual legal debates. And the aim is to bring these debates and these discussions to you wherever you are. And so I'm very pleased that today we have an esteemed group of speakers who will be talking about how COVID-19 has reshaped business and government relations across Asia. And our executive committee member, Professor Ng-Loy Loon, will be moderating today's session. So without further ado, Loon.
This topic is indeed very, very timely. Just last week, DBS organized a conference entitled, I think it's called Asian Insights Conference. And at a particular session, this session is called The Economics of a Pandemic. The former Minister for Finance of Singapore and current senior minister, Mr. Tharman Shanmugaratnam, he was a panelist, and he said this, right, during this session. I quote, "I've no doubt that governments will grow in importance." And he also added that this growing emphasis on governance will in fact outlast the current COVID crisis. And he went on to say, ultimately, we need a new way of ordering the relationship between the state and the markets, right? Now, so the topic is, as I said, something we want to explore more deeply today, and we have a very distinguished panel of speakers. Now, what I'll do right now is to introduce each of the speakers in the sequence that they would be contributing. We'll start with China, and for China we have Jiangyu. Right, Jiangyu, as Jaclyn said, is with my former colleague, and it's really, really good, Jiangyu, to be working with you once more in this collaboration. Now, Jiangyu is a professor of law, and he is, I repeat, the director of the Center for Chinese and Comparative Law at the City University of Hong Kong. Now, he's also the editor-in-chief of the Chinese Journal of Comparative Law, and amongst his many very, very highly regarded scholarship is his book, Company Law in China, Regulation of Business Organizations in a Socialist Market Economy. So we really have an expert on China here. Jiang, you understand that your second edition is coming up soon, right, of this book? Right, then we move to Hong Kong after China, and here we have Dr. Chunyan. Chunyan is with City University of Hong Kong, and she has degrees from Hong Kong, from the UK, as well as from China. She's also a qualified lawyer in the PRC, and before joining the law school in CityU, Chunyan was a Fulbright Research Fellow at Harvard Law School, where she conducted research on comparative health law and tort law during 2008 and 2009. And you know that public health is going to be a big issue in this discussion here. Now, she has authored many books and publications, and one of which is her book, Medical Negligence Law and in Transitional China. And then after Hong Kong, we'll move to India. Now, India, we have Umakanth. Umakanth is a very valued colleague of mine. Umakanth is our really expert on mergers and acquisition, and I can tell you that his module, mergers and acquisition, is one of the most popular, right, amongst our students. He is also researching in, well, generally corporate law and governance and corporate finance. And there is a specific focus on India and Singapore. And I understand that Umakanth is a very, very much sought after lawyer on India's company law. Now, one of his books, among many, is the one on mergers and acquisition in Singapore. And finally, we move to Vietnam. And for Vietnam, we have Trang Nguyen, who is an assistant professor of law at Temple University Beasley School of Law. And May's research focuses on transnational business governance and comparative law. So, Jiangyu on China.
I'm very glad that my center, the Center for Chinese and Comparative Law, can co-organize this event with CAOS. Let me jump to China quickly. So with respect to COVID-19, China has appeared to be the first in and the first out case. So the China, as everybody knows, the coronavirus broke out in China, in Wuhan, and China, not long after the discovery of the infection, the China took very draconian lockdown measures. So it locked down the whole city in basically in January this year. And then it locked down almost the whole country. So the economy was almost paralyzed. So in the first quarter, the Chinese economy contracted by 6.8%. So this is really an extraordinary case for China. Although it has become a new normal that countries are suffering from shrinking economic contraction, but this is very extraordinary for China because China has, before this, China never experienced. I'm talking about the PRC after, since the reform and the opening up period. So since the late 1970s. So since then, China has never experienced any real economic or financial crisis for about 4 decades. So China weathered rather well during the Asian financial crisis and the global financial crisis. So the Chinese leadership actually didn't have much experience in dealing with economic crises. Even in its worst time before this pandemic, China's lowest economic growth rate was about 6%. It was about 6%. So since the late 1970s, its economic growth rate never went below 6%. But as a result of the coronavirus, its economy shrank by 6.8% in the first quarter. So that's something we have to take note of. But now there are many signs to suggest that things are coming back to normal in China. So Chinese people, Chinese economy, Chinese life is coming back to normality. And in the second quarter, the Chinese economy grew by 3.2%. Now, if you follow the news in China, then the people are coming back to restaurants, to sports field, and to the trains, and to taxi, to MRT. So the society seems to be in the reopening process and coming to its normal condition. Although there are warnings here and there in some localities, you have kind of cases ticking up to a little bit. But now China is moving. Looks like China is moving out of the of the pandemic. So it's coming back to normal, and it is recovering from the unprecedented economic contraction, and lockdown measures are being ended. and so the economy is picking up again. I'm going to do a very brief summary of what the Chinese government has done from the perspective of state and business to rescue the economy. But let me first of all point out three general features in this round of the Chinese measures. The first one is in stark comparison with other major economies, so the US, European Union, Japan, they all offered huge stimulus packages, right? So they give a lot of money to their people directly, and they provide tremendous financial and other assistance to their firms. China seems to be holding back from spending on big stimulus packages. So the Chinese government has never announced any stimulus packages. So as I will illustrate in the below, so China has adopted a variety of many small measures. So each measure individually look rather insignificant, but maybe combined they work a bit. But the Chinese government has never launched any big stimulus package, and there's no money given directly to its citizens. Yeah. And second feature is the rescue measure have been focused on small, medium-sized, and macro-sized firms. So in Chinese called the 中小微企业. It's not much has been done to help the big firms. The third feature is the priority of the government since February this year has been getting the economy reopening. So getting the the factories to reopen without too much government assistance. So as long as you reopen and the workers go back to the factory, that itself is a success. So the government actually offered quite a lot in kind of support, but not very much financial support. So let me quickly go through some of the measures taken by the Chinese government. So the first group of measures are those monetary and financial and fiscal measures. So again, as I mentioned, the Chinese government didn't give money directly to the people, but the financial system, especially the People's Bank of China, which is China's central bank, and the commercial banks, they increased the liquidity in the market. So the People's Bank of China offered cheap loans and other financial help to commercial banks by open market operations. So asking those banks to provide cheap loans to small, medium-sized, and micro firms. Right? And so the Chinese authorities also ordered the banks not to call back the loans for those small and medium-sized firms which are stuck, which suffered from the pandemic. So by direct orders. So if the firm is in financial difficulty, it's a small firm in financial difficulty, supposed to pay back the loan, then it can be delayed, right? Not in the form of a law like what Singapore did, but through numerous orders, right? Directly administrative orders from the relevant authorities. So so not much tax support as well. So the Chinese government didn't offer generous tax exemptions or tax reductions. So the only thing it did was to allow firms in those affected areas, initially in Hubei and later in some other areas, to defer the payment of their income tax, corporate income tax, during the COVID-19 controlling period. I think this is still the COVID-19 controlling period in China. But there's no tax there's not much tax reduction, so you still have to pay it. Right? Even corporate income tax, you still have to pay it. But because of the COVID-19, it can be deferred. It can be deferred a little bit. So this is the first group of measures, the fiscal, monetary, financial, and the fiscal measures. The second group of measures are labor policy related. So in the very beginning, so there, and in terms of the labor policy, we can see a shift from initially pro-labor policy to later, the second stage, pro-employer, pro-business policy. So at the outset of the pandemic, so China suffered huge job losses. So the officially announced the job loss rate was almost 6%, which was very high by the Chinese standard. And also we have to understand that the officially published job loss rate does not include the rural area. So it only counts the urban area. So if you're a farmer and you don't have a job, so all the farmers, because they have lands, right? Because of the job loss, and also many firms were forced by the financial difficulty to fire workers. So the relevant authorities in China, the ministries, ordered the firms not to fire employees in the first part, right? In the first part of the pandemic. Later in February, since mid of February, so the overall policy orientation of the Chinese government shifted to resumption of work and the production. So the government in the second half of February, the Chinese government asked the factories, companies to reopen, and asked the workers to encourage workers to go back to their factories. And the labor policy since then has shifted to pro-business, to be pro-business. So so which basically was kind of a push, right, to ask the workers to go back to work. If you don't go back to work, then the government has no sympathy with you. So you go back to work, and then the government will help you. If you don't go back to work, and on the ground of you are suffering from the pandemic, then you probably won't get much help from the government. The government even ordered labor cases, labor lawsuits to be suspended. Right? So and in most cases, those labor lawsuits are the workers suing their employers. Right? Ask those labor cases to be suspended, the court not to trial those cases, delay the trial of those cases. The government also served as the coordinator between the employers and the workers in case those workers have disagree with what the employers did. So this has all been done on the rationale that you should go back to work, right? And the factories should reopen. The Chinese economy should be reopened. Right? So another measure, very quickly, the measure is the Chinese government worked on improving business environment to make it easy for firms to reopen, for new firms to be established. The government also even ordered kind of logistics help to get the workers to their factories. Right? For example, the government provided in many localities, the government provided free transportation to get the workers back to their factories. The last group of measure are infrastructure investment. Not very significant because the Chinese government proposed a new infrastructure investment with focus on 5G, artificial intelligence, industrial internet, big data centers. But those are long-term plans, not aiming at rescuing the economy, not aiming at having immediate impact. So very quickly, half minutes to summarize my major points. The first is China has adopted a wide range of monetary, financial, and fiscal measures, and also the labor measures. Those measures are of great numbers and often look very messy. There's no single significant measure, especially the Chinese government is avoided large spending packages. Right? The second point is most of the measures are administrative orders in nature, so they do not have a clear legal basis. So they are just, so in response to an urgent situation, you have a direct order from the government, which you cannot find a clear legal basis. So in comparison with Singapore, the government enacted a law first, right? Parliament enacted the law first. So the third point is China's policy and regulatory responses suggest that it now puts job security and social stability above GDP growth. So this is indeed a dramatic shift from the GDP-centered approach, which China has followed for decades. Right? And the fourth observation is at the current stage, China's chief strategy in dealing with economic problems, it seems to be pushing for the resumption of work and production rather than direct government help. Thank you very much. I may spend the extra minutes.
Right. Thank you, Jiangyu. So Chunyan.
Thank you for the invitation and the introduction. So I will have a PowerPoint now share the screen. So I will just borrow the theme of the roundtable. That's why I named this part as how COVID-19 reshaped government business relations in Hong Kong. Different from China, mainland China, and Hong Kong actually has never taken any very serious measures like a lockdown, okay, so far. Although it is now experiencing the third wave of the virus, so government may take additional measures. So I'm going to talk about three issues. First is talk about the anti-epidemic fund in general, which has been adopted by the Hong Kong government. And second, we will look at the major relief measures and for business to support the business in Hong Kong. And finally, I will briefly discuss the influence of those measures on government and business relations. So since early this year, Hong Kong government has taken a series of the reliefs, which now reaching Hong Kong dollar 219 billion, which is equivalent to 9.5% of Hong Kong's GDP. Specifically, there are 3 rounds or 3 stages, and so far taken by the government. The first round reaches around the $30 billion. The second round actually is part of the 2020-21 budget. It's the relief package amounting 120 billion. The second round was released in April with the aiming at job retention, job creation, and job advancement. And this third stage, the government assigned $137.5 billion. The government expressed the purpose of such anti-epidemic fund in fourfold. One is to help business stay afloat. Second, to keep workers in employment. Third is to relieve financial burdens of business. And finally, to assist the economy to recover once the epidemic is contained. So now I look at the specific schemes which has been taken by the government. So the first one is employment support scheme. In terms of the eligibility, and both large companies and the SMEs, small and medium-sized enterprises are eligible to apply to this scheme. The government has made
the budget of 80 billion, who is making MP fund, that is monetary pension fund contribution, will be eligible to wage subsidies of 50% of employees' wage, subject to a cap of 9,000 Hong Kong dollars per person per month for a period of 6 months. In return for undertaking not to implement redundancy, no pay leave arrangement or reduction of wages. For those employers who are not making MP fund contribution, but are in the catering, construction, and transport industry, they will be assisted by the government in sector-specific schemes. In addition, a one-off grant will be given by the government to self-employed persons who make MP fund contributions for themselves. Then the second scheme under the overall anti-epidemic fund is called one-off subsidies for financially distressed businesses, which also cover different sectors and different type of the company. Recognizing that some businesses were hit harder by the COVID-19 pandemic than others, the government has taken to providing a series of tailored responses for 16 type of sectors that have predominantly customer-facing operation, including tutorial schools, tourism industry, construction sector, aviation sector, catering sector, and entertainment sectors. Then the next one is focusing on SMEs. The government offer financial assistance to SMEs. In Hong Kong, SME has been defined as manufacturing firm which employ fewer than 100 persons in Hong Kong, or non-manufacturing firms which employ fewer than 50 persons in Hong Kong. So the purpose is to ease the cash flow pressure of business. Under this scheme, actually, there are two subcategories. The first one is government loan guarantees. The government offers assistance to SMEs in order to obtain financing from lenders by providing guarantee coverage. So for the maximum loan varies, as I showed here, and then the government will offer the different type of the percentage of the guarantee product. And for the interest of time, I will skip to the next one, that is SME exporting market funding. And this fund is aims to support the export promotion activities in market outside of Hong Kong. So business in Hong Kong, those SMEs, they can apply for this scheme. The cumulating funding per enterprise is capped $800,000, and each export promotion activity is eligible to 50% of the total approved expenditure incurred, or Hong Kong dollars 100,000, which is lower. If a company has already received funding support on this scheme, then the cumulative amount of funding cannot exceed 800,000 Hong Kong dollars. So those eligible export promotion activities, including trade fairs, exposition outside of Hong Kong, business mission outside of Hong Kong, and the government actually listed a long list of the activities that they can get sponsored from the government, and also including those platform advertisement, and the company want to targeting a market outside of Hong Kong. Okay, the next one is the technology voucher program. So the purpose of this program is to improve the productivity or upgrade or transform business process with the use of the technological service and solutions. The cumulative funding per company is $600,000. The applicants must contribute no less than 1/4 of the total approved project cost in cash. Each company can get or enjoy the benefit of the program up to 6 projects, and applicants is not allowed to undertake more than 1 TVP project at the same time. Okay. And In addition to these measures, the government also released tax and other relief measures during the time of epidemic, such as the low repayment relief, which is offered to self-financing post-secondary institutions and non-profit-making international schools. They can enjoy interest-free deferral of government loan repayment for 2 years. Tax referrals, and for those deadlines for payment of tax for year 18-19, which are due for payments in April, May, and June this year, will be automatically extended for 3 months. And also, the government offer the profits tax reduction for the year of 1920, which has been reduced by 100%, subject to a ceiling of 20,000 Hong Kong dollars. The government also offered the rate of the non-domestic property, which has been waived for the year of 2021, with the ceiling per quarter in first 2 quarters is Hong Kong dollar 5,000, and then the remaining 2 quarters the ceiling is 1,500 Hong Kong dollars. Then it is the reduction of utility bill. The company who which apply to this benefit, they can get the electricity charge for non-residential account. Then 70% of the charge for 4 months will be subsidized by the government with a cap of 5,000 Hong Kong dollars. Water and sewage charge of non-domestic household similarly also get 75% of charge for 4 months subsidized by the government. And finally, if a company is leasing from rent the government property, then they can get the rental subsidy, specifically 70% rent concession for 6 months. If the business completely cease operation, then they can receive full rental waiver.
Chunyan.
So, yes.
Chunyan, 10 minutes.
Okay, good. This is my final slide. So now I will discuss the influence of the government measures and on the government business relation in Hong Kong. So Hong Kong approach is different from Singapore, as Jiangyu has mentioned. I guess like a speaker will spend more time on the Singapore approach, which adopt a legal solution and to release a temporary legislation and to change or modify law in order to rescue or help the business in order to survive in this difficult situation. Then you will see most of the measures taken by Hong Kong government actually is relating to the financial assistance to the business, both to the large company and the SMEs. And traditionally, Hong Kong government is taking a policy of pro-business, positive non-interventionism. So they heavily rely on the market force and prefer deregulation over regulation. However, this situation has been changed since 1997 with the changing political economic order since then, with the fragmentation of business interests, as well as the populist demands and from a civil society. The original or traditional non-interventionism policy has been challenged a lot. In particular, in the time of the COVID-19 pandemic, the government actually is required by the different sector of the society, also including the business sector, and to actively take action or measures to support the business, to help people, covering both large corporation and SMEs. So whether their measure is timely and effective is not only a matter of political legitimacy and also has been seen as a test of governance competence. So far, it is quite early to see whether the effect is good or not, but I just saw some data, and this year, the unemployment rate in Hong Kong rise to the 6.2%, highest in more than 15 years, almost double the rate of 2019. So we still need to wait and see and how those government measures is working or take effective. On the other side, and criticize over those measures has been heard from different parts of society, and which relating to the very vague criteria for the resource allocation among different sectors, among different parts of the economy, and also whether the implementation is good is a problem. So this is the very brief kind of information I want to offer to you relating to Hong Kong side. Thank you.
Thank you, Chunyan. Umakanth, you are next on India. And perhaps, Umakanth, you're also the most appropriate person in this panel, to say a few words about Singapore, since in fact, Singapore has been mentioned by the earlier two speakers.
Sure. It's indeed a pleasure for me to be here and to join this panel to discuss on a very important topic that we are facing currently. And as Loon mentioned, I will cover India primarily, but the way I might do it is to try and bring in parallels to Singapore, or probably more likely contrasts to Singapore and how Singapore has dealt with in some of the issues that I'm going to be talking about. So let me begin with India. India suffered the impact of COVID-19 sometime in the middle of March. And one of the things that the Indian government did, and which had significant economic impact, is it imposed a lockdown of 1.3 billion people by giving 4 hours notice. Right, so economy came to a standstill. It was a 21-day lockdown that got subsequently extended for a period of time. And currently, there are different types of lockdown in different parts of the country. So this led to a huge impact on business. I won't have the numbers or discuss the numbers just yet, but you can imagine the kind of impact this may have had on GDP growth as well as contraction to the economy as a whole. And this has also had a huge social impact. And one of the things that has been carried by the international press is workers who were left in the cities high and dry because they could not go back home. And they were literally walking hundreds of kilometers back to their homes, and several of them fell ill, and some of them died as well, unfortunately. So it's not just had an economic impact, but it's had a significant social impact as well. But one of the things that we need to keep in mind when we think about the business sector in India is, like Jiangyu mentioned about China, there is both the formal sector of the economy as well as the informal sector of the economy. And the informal sector is really huge in India, just in terms of proportions. Just to give you an idea, according to ILO statistics, 86% of employed Indians work in the informal sector. And even more gravely, 94% of women who are employed in India actually work in the informal sector. So it's well and good to speak about, the relationship between business and state, and what the state can do and so on. But I think one of the challenges that is going to be there in India is how much of this stimulus and other packages that we are talking about actually percolates down to the informal sector of the economy. So having said that, India, unlike to some extent China, has indeed come up with stimulus packages, some of which are meant for industry, others are meant for individuals and so on. So what I'm going to do in this discussion is probably steer clear of some of the details of the stimulus packages, but maybe try and identify 3 aspects where we can think about the linkage between the government and the business, and how India has dealt with, and maybe compare it or contrast it with how Singapore has dealt with. So I'm going to use the 3 arms of the government to examine the relationship between business and the government. So let me begin with the executive arm of the government. When we think about the Indian scenario, there is quite a bit of parallel from the Chinese scenario that Jiangyu painted, which is the executive arm of the government has been at the forefront in coming out with the office memoranda, circulars, notifications on a day-to-day basis almost on various different aspects of the economy. This could include how to deal with contracts, it could deal with employment laws, it could deal with issues of taxation, corporate law, and so on. So there's a whole host of regulation that the government or the executive arm of the government has been coming up almost on a day-to-day basis, which means there's a fair amount of diffusion, which perhaps in a sense also creates uncertainty from a business perspective because things are changing on an ongoing basis. But fortunately, a lot of these are also relaxations that the government is making. So if there are some filings that need to be made, there are difficulties in making those filings now, whether it's filing tax returns or filing your corporate returns. All of these are being extended over a period of time. And one of the interesting elements that has come up here is, how does the government deal with contracts? And this has been an important challenge in the Singapore context itself. So to what extent should the government interfere in the sanctity and freedom of the contracts which parties have already entered into, but have now raised difficulties in terms of implementing or completing or operationalizing those contracts due to COVID-19? And interestingly, if we look at India, the first example of how to deal with contracts actually came from the executive arm of the government. And this came all the way from in March. And it was actually interesting. This shows how fast the pandemic has spread. In March, the concern for Indian companies was, how do we deal with supply chain issues when raw materials, other products are coming from China? Because at that point of time, China was at the forefront of the pandemic, but the concern from India is not how it has spread in India, but how Indian businesses have affected because the supply chain exists in China. And one of the interesting ways by which the government dealt with is, in the normal force majeure clause, there is a word called natural calamity. And the interesting question is COVID-19 a natural calamity? And the Indian government stuck its neck out and said, yes, for all interpretation purposes, we would like businesses to treat COVID-19 like a natural calamity. And this was what the executive arm of the government did. It applies to private-public partnership contracts, other government contracts, but it was only a kind of an advisory for the private contracts because they are not bound by what the government executive has to say. So that's kind of the executive arm of the government. But the contractual element has also flown further into the judicial arm of the government. So since March, the Indian courts have been flooded with contractual disputes on whether a party can get out of a contract because of intervening circumstances arising out of COVID. And here, there are two ways that the Indian law deals with from a contractual perspective. The first question to look at obviously would be, is there a force majeure clause or not? Because if there is a force majeure clause, courts largely have to interpret the clause because the intention of the parties is evident from that particular clause. And if there is no force majeure clause, then the regular Indian contract law will apply. And the question is whether COVID-19 amounts to a frustration or an impossibility, which will excuse a party from deviating from that contract. And the problem with these types of transactions or problems ending up before the courts is ultimately courts will have to decide based on the facts and circumstances of the case. And courts have indeed differed on individual circumstances of each case on whether the contract should be something that the party should perform or the party has to get relief because of COVID-19. And a number of issues could arise. First is, what is the nexus between COVID-19 and the lack of performance? Is there a nexus or not? If not, there is no justification to let the party get out of the contract. And the second, and I think the more tricky question is COVID-19 a temporary phenomenon, or is this going to have long-lasting consequences or not? Because courts often take the view that if it's a temporary blip, if it's a temporary scenario that leads to non-performance, that should not excuse. Maybe there's a delay that can be granted, but it should not let the party get out of the contract. But if this is something that's going to be long-lasting in nature, then it's going to be more difficult for the parties to get out of the contract. And so Indian courts have been grappling with these issues. Indian courts, I won't get into the technicalities of the law, but as you can imagine, the bar to be able to get out of a contract is pretty high. And unless parties have been able to establish that high bar, they have not been able to get out of these contracts. So there are many cases. In many of these cases, courts have said you have to perform the contract. We're not going to let you get out of the contract. And this is a very interesting time to contrast this with what's happening in Singapore, because the strategies that Singapore has adopted on contract law is to legislatively intervene rather than to largely leave it to the courts. So that's where you have this COVID-19 Act that has been enacted in Singapore, the COVID-19 Temporary Measures Act, and that provides for a legislative prescription in how to deal with contractual situations. And the urgency of this is understandable, because the literature indicates that this act was actually drafted in 9 days. It is a very urgent measure that was introduced. And what we find in this is much more detailed prescriptions about how contracts can be got out of if a party is suffering from the consequences of COVID-19. So firstly, I think it's pretty unusual for governments to intervene in contracts, and Singapore has taken the step to do so in this case, given the unprecedented scenario that COVID-19 has given rise to. And it is not all kinds of contracts that are covered by it. There are certain types of contracts that are entitled to temporary relief. And the more important part is the Act is very clear that the non-performance must be due in material part due to COVID-19. So the nexus is necessary, and the affected party may have had to give a notice that this person cannot perform because of these reasons relating to COVID. And what I find very interesting here is, even though it's a legislative prescription, there seems to be an attempt to not overburden the courts, because a lot of these issues are dealt with a new set of professionals called assessors, or part-time professionals called assessors, who will then look at whether, let's look at these contracts and determine whether it was indeed due to COVID-19 or not. So maybe there are different tracks. In India, there's a heavy reliance on courts, whereas in Singapore, it's a legislative prescription, but there is a sort of a temporary arrangement where a different body of people, professionals, peer reviewers, who come in and then decide whether these contracts need to be got out of, because perhaps these are more flexible arrangements. These are less rigid, as would have happened if these cases were to go to the court. So maybe it's kind of a very pragmatic solution that Singapore has adopted as far as contracts are concerned. And the third main aspect that arises here, and this is something which any pandemic or economic crisis will give rise to, which is how do we deal with bankruptcy? Because already there is a clear indication that many companies have become bankrupt, and news keeps rolling out from the US, especially about many large companies having gone bankrupt. We will see that happening even in the Singapore and Indian and other Asian contexts as well. So how does a government from a legal perspective deal with bankruptcy related issues? And even here, it's a very interesting contrast between what India has done and what Singapore has done, which then leads me to the third arm of the government, where India has actually legislated on how do we deal with the question of insolvency and bankruptcy in the wake of a pandemic. So unlike Singapore, which has had a more comprehensive legislative approach, India has gone more for a executive approach, to some extent the judicial approach, but when it comes to bankruptcy, India has gone through what I would call as a quasi legislative approach, because the parliament is currently not sitting. So there is an ordinance that has been promulgated by the president to reform the bankruptcy process to give rise to special issues that need to be considered in the context of a pandemic. Now, what happens in a pandemic? In a pandemic, we would expect creditors to rush to the court to take companies insolvent or bankrupt and use that as a means to restructure or recover their debt. So if you allow the current bankruptcy or insolvency system to go through the way it is, there will be a flood of cases which the judicial system will not be able to handle. And this is more of a concern in India than in Singapore. And the second is, if you want to restructure and revive and sell the company or the business of the company, the problem is there may not be enough buyers to be able to recover or revive the companies, or people to come in, step in, and then take over a company. So different jurisdictions have followed different approaches. What Singapore has done is simply, and many other countries have done, is simply raise the bar to be able to bring about an insolvency. So you increase the amount of the unpaid debt, which is necessary to establish that a company has become insolvent. So basically, you make it less likely that someone can take a company insolvent. And sometime in March, India did that as well. But what India did last month is to introduce a legislation which basically suspends the insolvency legislation for 6 months to start with, which could extend up to a year. So it's a very drastic approach that the Indian, as I said, legislative approach has taken, which other countries haven't taken. And there are advantages and disadvantages of this approach. Firstly, companies are not going to be facing or staring at insolvency. They are able to find other means to revive their businesses. But at the same time, the argument and critique from an Indian perspective, which Singapore doesn't face because Singapore hasn't suspended its insolvency regime, which the Indian situation faces is, if you're a company, if you're a defaulter, this is a great time because nobody, it's just a period for 6 months to a year. No questions asked. It doesn't matter whether your insolvency is because of COVID-19 or not. It's just
Okay. Umakanth,
yes,
15 minutes. So
yeah, sure. So I'll just end with that. So one of the concerns that's arisen is that because of this, India might be considered, this might lead to a defaulter-friendly framework leading to a lot of moral hazards. So with that, thank you, Loon, for the extra time. So, I've tried to cover both India as well as Singapore from both from the legislative, executive, as well as judicial angles. Thank you.
thank you, Umakanth. In fact, you've managed to do it with extra couple of minutes. So thank you very much. May?
Hi, thank you very much. And I'm honored to be on this panel today. So I want to focus on 3 main points on my remarks today. First is just a brief background on Vietnam's COVID-19 response as a backdrop for its business policy. And second, on the business policies put forth by the Vietnamese government relating to COVID-19. I will focus on 2 sets of policies in particular. And the first one is domestic coordination, and then the second one is trade policy, in particularly the recently signed Vietnam-EU Free Trade Agreement. And then finally, I will end with some takeaways on the revolving business-government relations in Vietnam. So first is the brief background. So by all measures, Vietnam has achieved quite an astonishing success in its COVID-19 response. As of today, there are 431 cases, including 0 deaths. And the last 15 cases all occur in the last few days after a 99 days period without any recorded community transmission. So the Vietnamese government has done many right things with the right speed to contain outbreaks. And one narrative has generally been overlooked is how Vietnam has sort of reaped the fruit of decades-long effort to professionalize its administrative state and to improve central-local coordination in the containment of COVID-19 outbreaks. And as you will see, these features are also critical in its business policies. All right, so onto the second part about business policy. So COVID-19, of course, has a grave impact on the Vietnamese economy, as with other countries that we have just heard about. A recent survey showed that most businesses in Vietnam, whether it's foreign or state-owned or domestic, have projected losses and layoffs. And so unsurprisingly, the government has stepped in with a host of relief measures, including employment-related measures, debt relief support. But I want to focus today on 2 particular set of policy that kind of go beyond short-term coping mechanism, because I think they have they will have a lasting footprint on the business-government relationship in Vietnam. And as I mentioned before, there's a domestic coordination and trade policy. So first on the domestic coordination point. So very early on, at the beginning when the pandemic hit Vietnam in the spring, the government has stepped in to coordinate purchases of course, by then highly valuable goods such as PPE, personal protections equipment, and COVID test kits. While that did not fully prevent the market reaction, it did mitigate it somewhat until supply could somewhat catch up. And that also intersected with the Vietnamese Communist Party's very high profile ongoing anti-corruption campaign. For example, the head of the Hanoi CDC was indicted for on charges of inflating the price of COVID-19 test kits. Now, domestic coordination has also become very important as Vietnam started reopening its economy in late April as one of the first countries to be able to do so. On the demand side, while international borders are still shuttered, there has been a national call to prioritize the domestic market, from tourism to domestically produced goods. And so city and provincial leaders have drew up plans to link up the domestic markets to promote domestic consumption. On the supply side, the largest efforts has been to reorient businesses towards high demand goods, serving not only the domestic market, but also to reposition Vietnam in the shifting global supply chains. And this, of course, concern personal protective equipment, medical devices, ventilators, but also supporting industries, especially in manufacturing and textile and technology industry, because of the effort to diversify away from China. And so while Vietnam likely stand to gain from other countries' desire to diversify their supply chains, Vietnamese businesses themselves, and similar to the case of India, 80% of these businesses are small mom and pop shops with fewer than 10 employees. And they heavily rely on China for raw materials and component parts. And so the government has provided all sorts of economic incentives, including corporate tax breaks, more favorable land leases, to incentivize companies to invest in these particular supporting industries. So this also related to the second set of policies, which is relating to trade. So the latest trade agreement, the EU-Vietnam Free Trade Agreement has just been signed and will become effective soon in the near future. Now this agreement has a very distinct feature, which is the dispute resolution provisions. It will set up a permanent dispute resolution mechanism with tribunal members appointed in advance by Vietnam and EU members. Once effective, this will supersede existing bilateral agreements, bilateral trade agreement, investment agreement between these member states. So Vietnam is then one of the first countries to sign up for this so-called new model of multilateral investment court. And that's a significant commitment from the Vietnamese party state to engage in formal international institution at the trade and investment level. So finally, to the third point, what are the key takeaways from these facts that I just tell you? And I have three main ones. So first is the showing of the growing capacity of Vietnam's administrative state. This, of course, didn't happen overnight, but is a result of decades-long effort to reform its law and regulations and to improve responsiveness, particularly at the local level. And related to that, the second takeaway is the shifting basis of legitimacy. So Vietnam is, of course, a single-party state. The Vietnamese Communist Party is institutionally linked to the government at all levels. And the basis of legitimacy, at least since the 1980s, has been economic growth. And kind of similar to Jiangyu's presentation on China, Now, with the benefits of comparison with other nations, there's now kind of a shifting sense that of the states prioritizing of public safety, public health above growth. And Vietnam's exceptional performance relating to COVID-19 has created a renewed confidence based on the state's capacity. And finally, the third takeaway. So COVID-19 kind of perhaps an interesting effect of this virus that is said to cause deglobalization. It has also caused Vietnam's even more increasing engagement with the international order, because it has created such a fracture in global supply chains, long dominated by China. And so as Vietnam is now quite aggressively seeking to capture these new opportunities, this has aligned business and government toward this common goal. Thank you, that's my remark.
Thank you, May. Okay, now we're in a very good position. We have, well, just over 10 minutes, right, to do the Q&A. Now, let me take a look at the Q&A. This question is directed at the Hong Kong situation, right? And therefore, Chunyan, perhaps, you can be the one to address this. And the question is this: were the Hong Kong relief measures on rentals, utility bills for only citizens of Hong Kong or extended to all? Also, for corporate entities, was there a requirement to have a local shareholding percentage to qualify for relief measures?
Okay, thank you for the question. I think that maybe the question is like here, the question mentions citizens, but I want to focus, actually, we talk about business, okay? So in Hong Kong, and for those relief measures imposed by the government, not only like it's because I actually covered a series of the reliefs. So if only talking about the rental and the utility bill, actually the government will offer to the business in Hong Kong rather than the citizen of Hong Kong. And then the second part of the question is about the eligibility and whether local shareholding percentage. So far, it doesn't show that. More specifically, the government require the company must be registered in Hong Kong under the Business Registration Ordinance, that is Chapter 3.10, and or incorporated or registered in Hong Kong under the Companies Ordinance, Chapter 622, and also one require those companies established in Hong Kong must have operations in Hong Kong. So it does not require a local shareholding, but more specifically, it is the business, focus in Hong Kong, operation in Hong Kong, and then registered under the relevant Hong Kong ordinance. Thank you.
Right. Okay. Thanks, May. If I'm not wrong, in Singapore, at least for, say, utility bills, it only applies to a household where there is a Singaporean. So I suppose that's where this maybe perhaps the slight difference lies. Now, the next question is from Chunyan from NUS Law, our Center for Law and Business. Now, have law courts or policymakers in India and also in Singapore considered the COVID-19 as a type of force majeure or rebus sic stipes? I hope I pronounce it correctly. And that's followed with a thanks.
Thanks, Chunyan. I think the very quick answer is yes. I think both jurisdictions have considered this as force majeure or rebus sic stantibus, because the reason is, but the method and the approach that they've adopted are different. In the Indian context, it's courts which have recognized it. But as I mentioned, the bar to establish that as a means to get out of the contract is extremely high. And what is interesting today is, from a litigation strategy perspective, given the novelty of this issue, this issue is actually coming up in situations which are leading to interim reliefs only. So one party wants an injunction saying the other party should not demand money from me, or should not be allowed to get out of the performance of the contract. So currently these cases in India and the judicial situation is at interim relief stage. Maybe they're not final decisions yet. We will take some time before getting there. But I think the answer is yes, you can invoke that. And in the Singapore context, it is done through legislation. Because I think what we see in the COVID Special Measures Act is effectively a legislative incarnation of the force majeure situation, with COVID-19 becoming that situation, but in a very, very specifically prescribed set of circumstances.
And then the next question, or two questions from Lance from Kels. And these two questions are for Jiangyu. First question, how has COVID-19 influenced the governance of SOEs and corporate governance in general in China? And the second question, how do the Chinese courts treat contractual obligations affected by COVID-19, force majeure, etc.?
Thank you, Lance, for the two wonderful and really very important questions. In my presentation, I mainly addressed the policy and the regulatory responses from the Chinese government. So your two questions are actually get directly to the legal part. So the responses from the Chinese government to those many, there are actually hundreds of documents have been issued by the Chinese government. That's why I said they are very messy in the form of decisions, notifications, circulars, replies, opinions, and guidelines. But they are all, to a large extent, enforceable laws in China, not in the form of official laws, but are actually enforceable laws. And they have incredible implications on corporate governance and contractual transactions in China. The last question was very much about state-owned enterprises. A lot of those documents, those decisions, circulars, whatever they are called, have made decisions directly for companies. For example, the example I mentioned, that the commercial banks were asked to, on the one hand, they receive cheap loans, right, from the central bank through open market operations. On the other hand, they are asked to delay the payment of loans extended to small and medium-sized and micro-sized enterprises. And so this is actually, this is both a direct interference in the decision-making, so in the corporate governance system of a bank, which is in most cases, or actually in all cases, because all the commercial banks have been corporatized, so they are companies, they are state-owned companies. So which basically means that a decision has been made for them on behalf of the state, on behalf of the authorities. So the bank's own corporate governance institutions have been put aside. But of course, this is a universal phenomenon at this stage. Many governments have done this, but in China, it's done through those what I call administrative orders. And also, one of the circulars require state-owned entities, including state-owned enterprises and state-owned universities, right? Universities and all the business directly owned by the government to reduce or waive the rate. So waive the rent, right? Waive the rent for several months for small and medium-sized enterprises. So it's a direct order to the state-owned entities, ask them to forfeit their income. So that's also that's both an interference in the decision-making system of state-owned enterprises, and also an interference in the contracts, right, in the lease signed between those entities and the enterprises, right, and the small and medium-sized enterprises. So you can find actually a lot of examples to indicate a very heavy degree of interference into both corporate governance mechanisms as well as private contractual transactions in China. And the ironic thing is, seems they have worked quite direct, quite efficient, and quite effective. So that's why China is kind of a first in, the first out case. The Chinese economy is coming back. So which to quite a large extent demonstrate the unique Chinese model of governance from a law and development perspective. Is there so in response to your second question, actually, also to the first one as well, actually, there are also judicial responses, legal responses as well. The Supreme People's Court of China, the SPC, as both as China's top court, as well as a lawmaker, because the judicial interpretations issued by the Supreme Court of China is a very important source of law in China. So the SPC is also a lawmaker. The SPC actually issued a variety of, I think they are less than 10 of them, judicial interpretations to respond to the rising disputes, so lawsuits brought to the court in relation to COVID-19 and COVID-19. My colleague Liu Qiao has actually just written a very good paper in this regard on how the Chinese judiciary, especially the Supreme Court, has responded to this by developing, encouraging the application of the doctrine of force majeure, and also the encouraging, also promoting the application of the doctrine of frustration of contracts. So this is also actually a wonderful example of legal transplant, because the frustration of contract, the idea, you can find legal basis in the Chinese contract law, but they are not much used, right? So this time it's being used, and it's being used on actually quite a large scale. Thank you very much.
Thank you, Jiangyu. Now, this question comes from Guang Yixi, and it's a question directed to all the panelists, all the speakers. It's a question really, really very, very interesting in nature. Now, the question is this: now, with each nation having a varying proportional structure between the state, right, including differing combinations of the legislative, judicial, and executive arms of governance, on the one hand, and then on the other hand, the markets, the person is wondering whether each nation's legal structure would allow for a new governance institutional structure, blending state and market capabilities. And he gave some examples, right, about how startup-based entrepreneur economy fuels mergers and acquisition activities within the MNC space. You also have cross-national companies, and you have governments, looking to build technological capabilities for commerce and governance. So with all this, and with also COVID as well, are we seeing the emergence, or is it possible to have the emergence of a new governance institutional structure that is slightly different from what we already have right now, where you might actually see two so-called entities, state on the one hand, right, the businesses on the other hand? Perhaps I can call on Jiangyu first.
Sure. I will be very quick, since I said too much about China already. Now this is a very, very good question. It's a rather abstract and philosophical question. In the case of China, which to a large extent follow a global trend, so you see the coming back of the state, right? So Singapore also offers a very good example. Even though it was, so the parliament enacted the law, which was according to Umakanth, it was enacted in 9 days. It was also a direct state interference into private relations, right? Into private ordering, and the only difference is it's done it's more legalistic, right? It's done in the form of an act, right? Of a law made by the parliament, and in the Chinese case, you have hundreds of various form of documents issued by various government authorities, but in essence, not much different, right? So direct state interference. You see the nation state is coming back. So more power has been shifted to the state in response to this emergence. And so in the Chinese case, looks to us that there's nothing new there, but to some extent, it's a reversal of a trend which started in late 1970s. So at the outset of the reform and the opening up period. So the Chinese economy, Chinese society was moving toward more legalization, was moving toward rule of law and the more power given to the private society. So those kind of direction in line with the Western values. With the COVID-19, because the government has to make emergent responses, has to issue direct orders, has to interfere into private relations directly, and also because it is a crisis, right? Because of the nature of the crisis, they were accepted by the society. So the whole situation has justified the coming back of the state, right? So more power is given to the state. In the Chinese context, there's nothing new here, right? So we see the old state coming back, and then coming back. So which has offered simple and effective solutions on the one hand. On the other hand, it generated uncertainties about the future, right? Coupled with the U.S.-China trade war. So many people in China are watching this rather worriedly. Thanks.
Chunyan, on Hong Kong.
Yes, it's a very good question, especially can link all speakers talk together. And from the Hong Kong perspective, I think it's also kind of have a phenomenon of past dependence, because originally like government is insisting on the policy of small government and the big market or big society. So in the case of a pandemic, actually government also thinking about this is the traditional or like the comfortable way and to dealing with that. Although there are a large voice, a big voice and or demand from the business, from the society. Different from Singapore, and Hong Kong does not use legislative solution, and also because of political reason, right? Currently, and the legislation is almost kind of half or quasi-paralyzed. And then government can take a quick response and only through the administrative measure. And also the judicial normally is quite ostentatious, and they will not aggressively and intervene the contractual relationship or even dealing with the bankrupt case. And in accordance with the current legal system. So you will see actually each country actually will take their approach and quite influenced by the origin or their historical system, governance system, political system, and the societal system. So I will show Hong Kong is quite on its own way, on its own path, okay, dealing with the pandemic. And of course, like it attracts a lot of criticism, and we will see actually maybe with the hindsight and say whether a better solution can be taken in order to deal with the situation. Thank you.
Umakanth?
Yeah, thanks. Very quickly, I agree with both what Jiangyu and Chunyan have said. But I think one of the things is we do admit that there's going to be greater intervention by the state. The state is going to make greater inroads into the markets. But is this going to be a temporary phenomenon, or is this going to have long-lasting effect? And one of the things to think about is, I think it also depends on the constitutional setup within each jurisdiction. If you look at a country like India, there's a whole jurisprudence of fundamental rights, including to carry on business and trade and profession. And these constitutional rights have withstood time. So maybe the state could make some inroads due to temporary pandemic-related measures. It could also change the way governance takes place in the relationship between state and the markets. But end of the day, I think the Constitution is a long-lasting document, and we need to think about these as more incremental issues rather than something that has a much longer effect.
Now, before I call on May, Umakanth, just as a follow-up, then what about the question of, do you think that businesses will actually start looking to the government for, or rely more heavily on the government to lead the way, so to speak, past the pandemic, to see where the economy should be going?
Yeah. So I think historically, at least from the Indian perspective, the government, reliance on the government ended, like in China in the earlier than that. From 1991 onwards, the market took on a greater dominance in the Indian context, and the role of the state in the post kind of socialist era went down. I don't see that reversing. Maybe again there, it's probably a temporary phenomenon where currently, because of desperation, businesses are looking to the government. But once things change and the economy is back on track, I would imagine that it might be difficult. And at the end of the day, this also depends upon how long this is going to last. If it's going to last a year, maybe the change is going to be minimal. But if it's going to last for a much longer period of time, then that would become the new normal.
Right. Well, I guess that my question was actually wondering about Singapore context, Yeah. But now, and May?
Yeah, so just I'll be brief in the interest of time. So in Vietnam, there kind of exists already a mini model of this, and it's called the Vietnam Chamber of Commerce and Industry, which is kind of a quasi-government, quasi-market body. So it's not quite the scale and scope I think that the questioner envisioned, but it's kind of a unique body that sits between the state and the market and acts as a coordinator for businesses, and it runs two highly influential indicators in Vietnam. One is called the Provincial Competitiveness Index that was originally partnered with USAID, the U.S. Agency for International Development, and also the a second index, PAPI, the Provincial Administrative Index, as a partnership with UNDP. And so in a way, it sits between all these various structures as a feedback mechanism.
Okay, now I know it's 12:30 and we should end, but there is one last question, and I'm allowing this because May, it is actually for you, and because you have not had any specific question about Vietnam. Now, this is actually from Duke Nguyen, so a Vietnamese, I would imagine, thanking you for your insights. And the question is this: do you think if the Vietnamese government will embark upon some kind of economic reform or changes in order to reap the gains from the pandemic, will the regulation or deregulation to a certain extent be put in motion in Vietnam, especially in terms of SOEs?
Thank you very much for your questions. So it's early and difficult to tell if there's really going to be kind of a huge wave of economic reforms like what we see in the mid-1980s, the Doi Mới era. But we already see a number of legal reforms on the way, and that's as a result of Vietnam's commitment to several trade agreements. So in addition to the EU trade agreement that I spoke of, there's of course the comprehensive and progressive Trans-Pacific Partnership. When the US was a partner, there was a lengthy legal component that would trigger reforms on labor law, including requirement for an independent labor union. Now, even though the US has, of course, withdrawn from that agreement, Vietnam has decided to still honor that particular appendix. And so there's certainly ongoing reforms in the labor sector. The EU agreement also has certain legal reforms component to it, most specifically relating to standards of goods, food safety. So we are seeing waves and waves of legal reforms on the way, and we would have to see how big that wave amount.
Right. Okay. Thank you, May. Now, with that, we've come to the end of this roundtable. Thank you very, very much for joining us.